Uh, Thank you everyone for coming out to tonight's event. Before we start out tonight, I just want to go over a few ground rules for how this Q&A will go. We don't do these events often, so it's important that we lay down rules before we tailor an event like this. As a refresher, this town hall is going to be for questions regarding CV 0212022, which is the sealed docket between Weazel News, CNT, and the LSPD. There were some questions that Judge Avery wanted to field and make sure everyone was on the same page with how the case went, just to provide so there's no miscommunication on that front. So with tonight, at no point does anyone need to be disrespectful or argumentative towards each other. This is designed to be an open form communication where everybody can get a basic understanding of what happened with this case. At no point does people need to talk over each other. Again, let one person talk at a time. And lastly, this event is again set for CV021, not for other cases. After all the questions are asked for this specific case, we'll go into anything else that people have for the judiciary and then anything else for the government as a whole. With that, I'll go ahead and let Associate Justice Avery come on up and take the floor. And yeah.
Thank you, Mr. Diaz. Good evening. As most of you know, I am Associate Justice Charlotte Avery. I'm currently a sitting magistrate of the San Andreas Supreme Courts. We're gathered here today to address the topic that has arisen from a recent civil matter, case number 2022 CV021, Los Santos Police Department versus Weazel News, CNT, and Ramsey Thompson. Excuse me. I agreed to hold this press conference to address concerns and questions from both the media and the general public. But I would like to preface this meeting by speaking to one of the biggest questions that spiraled into a heated topic, which was the First Amendment. First Amendment is a protected right of the people to free speech, religion, the press, and the right to peacefully assemble and redress grievances. As someone who started their career in constitutional law, I have always been and always will be true to that and continue to do everything in my power to protect the rights of any citizens protected under these protections. Now, with that being said, yes, freedom of speech and press are protected under the First Amendment. However, not all speech or written word in all forms are protected. Speech or written word that would be obscene, would defame by means of libel or slander, perjury, blackmail, that would incite imminent lawless actions, true threats, and or solicit anyone to commit criminal actions are not protected forms. When I was originally made aware of the civil injunction request by the state attorney's office by means of a private email alongside other judges, justices, and the Chief Justice himself, I was not formally assigned to the matter. I was, however, the first available in the email chain to respond, which I did and investigated into the matter. Once I was assigned to the filing, I ceased all private communications as I noticed that the defense was not included in said email. At which point, I sealed the docket due to the ongoing investigation being conducted by the Major Crimes Division and the sensitive nature of the information contained within the matter itself until such a time the matter of the injunction was resolved or the case with MCD was closed. My intent was not, nor was it ever, to suppress free speech or the media. It was to avoid any damage to an ongoing investigation into an individual that posed an imminent threat to the safety of the lives of those affected directly and indirectly involved, and to the general public. The measures I took were simply to ensure the least amount of damage possible to an active investigation, and more importantly, and most importantly, the safety of the citizens within the state. Situations like this can be unpredictable and quite frankly volatile. My first priority will always be the protection of the citizens of this state in every form. I'll get into my ruling on the original matter, as it is still part of a sealed docket. I feel comfortable considering what has transpired has passed, letting you know what my ruling was specifically and verbatim. My ruling on the original matter was the following. I will be granting the motions that the stipulations that the information concerning the bounty be removed and not published, and that the names of the witnesses be omitted. With the portion about the bounty being ordered to be removed, I do not have any legal authority to prohibit the article from being published. While I find the language used in the article to be highly inflammatory and potentially dangerous, a fundamental right to free speech must be maintained. Prior restraint is a dangerous power of the government that is not to be thrown around lightly. And in this case, should I order prior restraint, it would be a significant overreach of governmental power and the power vested in me as a magistrate of these courts. However, as we all know, stipulations in that ruling were almost entirely ignored, and I firmly believe that this is what led up to the death of Mr. Ray Fritz. I am not blaming any one person. Please do not misunderstand what I am saying. No matter my opinion nor the opinion of anyone else of the type of person or the actual person that the individual is or was, he was still a citizen of the state and was afforded the same rights as anyone else. His death at the hands of another citizen denied him the right to a fair trial for his alleged crimes, which led me to be made aware of the article that we're all familiar with that was released with information by the court order uh, that by court order was omitted, was to be omitted, and the language used within not covered being free speech. I stated the following. Also, a direct quote from a portion of the sealed docket. Uh, I am not sure how much more clear I could have been in my original order. The name of all witnesses were to be omitted, and nothing relating to a bounty was to be included. Any monetary reward being offered like this could cause harm, whether you say it is a bounty or a reward. It has the same effect, and quite frankly, I feel as though it advocates for vigilantism. With the current wording, had it been, quote, for information leading to the safe return, this would have been different. However, it states for the safe return. Bevins Garvey, Ray Fritz, Nigel Warshire, you'll have to excuse me, Nigel, if you're here. Your last name is extremely difficult for me. Worcestershire, it's probably wrong, are all considered witnesses. The publishing of this article may very well place the individuals at risk or of harm of death. The same thing for Mr. Alvis Pulley. Now that their names have been released as someone offering money to find Mr. Ray Fritz, may also put Mr. Alvis Pulley at risk. I put out an order for those things to be omitted. However, here we are with a pretty direct violation of that order. I will be in my office tomorrow to handle this. I cannot do anything about the article now as it has been published and released to the public. I sincerely hope, for the sake of Mr. Garvey and others involved, that this article does not result in further injury or worse, death for the sake of a new article. While this may seem like a harsh response, I was gravely concerned for the life of all involved, and especially Mr. Garvey, as at the time of the release of the article, he was still being held by Mr. Fritz. And my assertions of it causing someone to take matters into their own hands rather than allowing law enforcement to do the jobs was correct. A citizen was directly involved with the death of Mr. Fritz. Now, I will open the floor to questions and or any concerns that you would like to address specifically concerning this, starting with our friends with the media, and then we'll move along to the general public to address their own questions.
Harry Kennedy with Saint I've got one question. The court case is obviously sealed. How do you expect us to ask questions about something we can't view or, repeat?
So the majority of what was in that article that was released to the public is actually in direct relation to what was in the sealed docket, which I do intend to make that docket public in the coming days as the matter is closed and no longer poses a threat to the general public.
Just to follow up with that then,
Sure.
obviously we're here not, obviously the article is, a part of this, but the press conference was called in regards to the case itself.
Correct. And in relation to that case was centered around prior injunction or prior restraint because it was asked of the courts to place prior restraint, barring the article in its entirety from being released. There is some of the docket that is still public. Give me a moment, I can pull it up. As it is that I am, like I said, in the coming days, going to release this to the public since it no longer poses a threat. You'll have to excuse me. I will have to dig through emails quickly. If there are other questions, I'll come back to this one.
Justice Avery, it's Nick Adams, CNT. Couple of questions. First one, if you state that the docket no longer looks to be a threat, then why would it have not been unsealed prior to this so that the public and everybody here in the media who wasn't privileged to that information could actually ask you proper questions about it?
So the reason for that, there is a process to unseal a docket. And it's not a short process in order to do so. It does take time. This was, and I mean, that's obviously that is a failing on my behalf. I had probably, 24 or 48 hours before this was scheduled to have unsealed it. However, I have got to get in contact with the Chief Justice before doing so. I have to have his authorization.
Okay. And follow up, would you like to respond to the multiple counts of, or not multiple counts, but the multiple conversations about your misconduct in this case, or no?
Sure. Do you have a specific question?
Yeah, there's multiple times you spoke to the prosecution without the
There,
defense being
there.
present.
Okay, I'm going to correct you there. There was not multiple times that I spoke to the prosecution in relation to this case. There was a single email chain, which I will happily discuss to clear the air on that one as well. Give me a moment. Once again, I receive an immense amount of emails on a daily basis. There was a singular email chain that included Detective Alexander Ward, myself, Damian Underwood, another member of the Judiciary panel, the Chief Justice, Mr. Barrington, uh, Gerhard, let's see, Judge Syring, and another member, which would be another member of the prosecution's office. The original email stated, "Good afternoon, Your Honors. I apologize for the urgent email request. I'm reaching out to request for urgent judicial assignment due to the nature of the situation at hand for the aforementioned case," which would be the case we're discussing now, which is CV-21. I said, "What investigation is this pertaining to?" He linked a document that was handed that CNT and Weazel News were going to publish that pertains to the investigation, and it said it could be found here, and that the original document had since been deleted by the author. I said, I asked how the media got a hold of the information. He told me he was not entirely sure. They were able to obtain the information. The document was just provided to him the night before prior, at which point I fielded for emergency injunction. I've not had the chance to fully speak with either party nor Miss Ward in depth about this yet. I said, please include Miss Ward in this chain. I'm attempting to get in contact with Chief Justice McLemore now to see what we can do, because this is, it was in my mind, a large issue of safety for the public. And I asked Miss Ward if she had any idea how this information had been released. The only thing that I knew about it was that I said, I know the arrest warrant I signed is under seal, so I don't understand how this information was made public. At that point, I was officially and formally assigned to the civil case, at which point on February 21st, I stated also from this point forward, I will not be responding to this chain. I have been assigned the filing. As the other side is not here, I cannot continue private correspondence. Uh, at that point, I never replied. So that was the only instance in which I spoke to the prosecution, and this was uh, prior to my assignment to the filing. Uh, any other correspondence had both sides in attendance, to include the sealed docket, which had everyone that was pertinent to the case, defense or plaintiff otherwise, included.
Okay. Can we just go ahead and can we touch on what you said when you said please include the detective on this chain? You said you were attempting to get in contact with the Chief Justice, but you also had very strong feelings, and I quote, because this is going to end up getting someone killed if released. If you had such strong feelings going into the docket, why would you not recuse yourself from the case and then continue to make judgments on a case that you clearly felt so strong about?
Uh, I'll say this now that while judges are supposed to be viewed as, and I don't want anybody to take offense to this because I don't mean it as maliciously as it's going to sound, as robots who do not have feelings, I would venture to say that anybody that works within the judiciary is their own person. Not There's not a single case that any judge that they step into is not going to have some sort of feeling about one matter or another. When I took the case on and I was assigned to it, I did not recuse myself because I did not see any inherent bias, nor did I feel any inherent bias towards the case itself. Um, However, yes, I did have strong feelings about whether or not someone was going to get killed. And I find it interesting that you can direct quote a private email correspondence, but that is something I will address later and in private.
What? Huh?
And then one more question. Are you going to dispute the fact that you personally assigned yourself to the case?
I did not personally assign myself to the case, no.
Okay, no further questions.
If I go back and look at the docket, if I believe Judge McLemore was the assigning justice. I did. I'll I didn't assign myself to the case. However, I did tell him that since I was read in on it, that and it directly related to a criminal warrant that I had already signed, so I was familiar with the intricacies of the case. That if he chose to assign me to it, I would feel comfortable dealing with the matter. But that is not a self assignment, no.
Okay, and one final question, actually. Um, so, actually, you know what? Never mind. No further questions. I'm good.
Okay, if you're sure.
Harry Kennedy was seen here. I've just got one. It's kind of touching on a point that's already been brought up. In
Sure.
jury selection, obviously different to how judges get picked for different cases. In jury selection, if you have any knowledge about a case, you'll most likely be excluded from being set on the jury for presenting the fact that they're meant to be unbiased. Your prior knowledge about this case and opinion on this case, as seen apparently in this private communique, I haven't actually seen it personally, so I'm not 100% sure what was going on there. um wouldn't you need to kind of follow like the same thing of if you have prior information about this and a prior opinion, shouldn't why would should you kind of exclude yourself from the case?
Once again, it's whether or not the chief justice or the judge being assigned, when they look at the case, there's a series of questions that I'm sure every judge asks themselves, and the main one is, do I feel personally that I can remain unbiased in this situation or impartial to the situation? As far as jury selection, that is slightly different. Um, because of when you talk about a private party knowing of the case or having prior opinions about the case, um, it makes a difference for jury. You have private parties that will know somebody out here on the street that is directly related to a case. Judges, I see some of the same individuals in and out of my courtroom on a semi-regular basis. If that was the case, and I would have to recuse myself because I knew the person or I knew details of the case, which, to be fair, judges research the case before they sit on the trial, so they are informed themselves. They, I would have to recuse myself from 80% of cases that come across my desk, which is just not feasible. I can pinpoint at least 4 people in here that I know personally. If I had to recuse myself from four people's cases, that puts the load just strictly based on the fact that I know somebody or I know about the case. I will remind you that as judiciary members, we do have access to look up people's backgrounds. Um, this does not play a factor in my impartiality on a case that I am presiding over.
Did she just say she looks at people's
Sentencing is a
backgrounds?
whole nother thing, and I won't touch on that today.
What?
But I believe your question is why
Did
is
you
the
hear that,
standard
Cyrus?
different? There is a different of standard when it comes to selection of a
actually
jury versus the impartiality of a judge sitting over a case. The processes are pretty vastly different.
This is Mickey Rivers here with Weazel News. I have a question for you about this private email chain that you mentioned. You mentioned that it included the judiciary, the state prosecutors, and at least one detective. Is that correct?
That is correct.
Who was the individual who created this private email chain initially?
That would have been the state prosecutor that was assigned to the case, Mr. Nigel Barrington.
All right, thank you. I have no further questions.
That's fine. You can find that on the original public case filing as well, that he was assigned to the case.
Excellent. Thank you, Your Honor.
You're welcome. Have any other questions from the media? I'll take that as a no. Anybody else sitting here today that has questions?
I don't know if we're just going to shout this one out, Your Honor, but do you feel that CNT's ignorance of your request was more considering their previous articles on law enforcement's, I guess, quietness, a rebellion against law enforcement and judiciary as a whole to run the story against your wishes and by and right violate the inherent trustworthiness of a news agency to provide accurate information?
When you say ignorance of the court order against releasing that information,
such as the fact that you've quite clearly made in your statement that you had asked for the wording to be changed so as not to incite vigilantism, which, as I believe, Mr. Fritz was actually killed by a member of the public rather than law enforcement resolving the situation due to the wording, as well as the fact that several witnesses were named, which you had asked for their safety not to be named. They've flagrantly disregarded that in order to get a sensationalized article out. Do you believe that that in itself is something that, again, may have been purportedly brought on by their rebellion against law enforcement's and the judiciary by a whole history of silence in regards to sensitive cases until a resolution's made?
To be honest with you, is that Mr. Stryker? I have never really had any close personal dealings with CNT nor Weasel News for that matter. So I couldn't fairly say that it was a um, I guess purposeful violation of the court order. You know, I felt that I was clear. Maybe I wasn't. Um, However, as far as the question of ignorance of the court order, there should have been no ignorance of the court order itself, as they were all included in the sealed docket portion of this case. As I won't speak for their motives in releasing that article, because I just don't know. I'm not in the heads of the individuals that work for either media outlet, so that's not for me to say. Are there any other questions? I'm gonna take that as there's not any other questions from the general public or the media at this time. Um, I don't know if there is anybody else sitting to my right that wishes to speak on this matter, but this is where I am going to make my exit. Um, and I will leave you with, if there are any other questions that you have that come up later, I will be happy to answer them. My phone number is of public record, and my office is almost always open when I am in the office. I have an open door policy, always have, always will. Anybody is able to come and talk to me candidly at any time. So, with that, I will give it back to whoever is taking it over.